students, welcome to Drishti IAS. My name is Saloni Nandkyoliar, and in this session we are going to talk about the 53rd Chief Justice of India, Justice Surya Kant, as he recently took oath on November 24th, 2025. In fact, we'll talk about the evolution of the entire appointment system of the judges of Supreme Court and High Court. So let's start with Justice Surya Kant. So Justice Kant has sworn in as the 53rd Chief Justice of India, and he took charge from his predecessor, who was Justice Gavai. Now we've already made a detailed video on the appointment of the Chief Justice of India. Please go ahead and check that out. The link to that will be pinned for you in this video. Now, who administered this oath to the Chief Justice of India? So as per the Constitution of India, the President administers the oath to the Chief Justice of India, and this oath taking ceremony took place at Rashtrapati Bhavan. Okay, so Justice Surya Kant has sworn in as our 53rd Chief Justice. Now, it becomes important for us to know about a background of his cases because he has been involved in some landmark judgments. So what landmark judgments are we talking about here? The most important one is the 16th Presidential Reference Bench. The 16th Presidential Reference Bench. What did this bench say? So the bench said that neither the President nor the governors, in the case of state bills, neither the President nor the governors will have to comply with any timelines that have been imposed by the Supreme Court. So please understand what happens is that whenever a bill is presented to the President or the Governor, we're talking about state bills here, they'll either assent or they'll either withhold their assent. So what happens many a times, they even delay the bill because they take no action on the bill. They neither give their assent to the bill, they neither withhold their assent, they only delay the bill. So this is something that was taken to the Supreme Court, and the Supreme Court earlier had said that the President and the Governors will have to act within a reasonable time frame. So it kind of imposed a timeline. It said that they'll have to act within a reasonable time frame. But this 16th Presidential Reference bench over here, it said that neither the President nor the Governor, so it basically overrode the earlier judgment that these people are not supposed to comply with any timeline that has been imposed by the Supreme Court, because the Constitution itself does not define any timeline, does not provide any timeline. That is why the judiciary will also not impose any timeline, and any such imposition will be unconstitutional. That is why, so the President and the Governors are not supposed to comply with any timeline that has been imposed by the Supreme Court. This is a very landmark case, a very landmark judgment that Justice Kant was a part of. Then he was also associated with the special intensive revision of our electoral rolls that are taking place at the moment. Then he was also associated with the farmer protests of 2021, where the judiciary had to strike a balance between the right to protest and the right to free movement. So he has been associated with some landmark cases, and in fact the goal that he has in mind at the moment is to work on the pendency of cases in the Supreme Court. You will be amazed to know that there are some 90,000 cases that are pending in the Supreme Court. So Justice Kant has said that he's going to work towards reducing the pendency of these cases because the number here is very high, and he also wants to increase the use of technology. in the working of the court, so as to ease the life of the lawyers, the judges, and even the citizens. In fact, there's already an official app that has been launched by the Supreme Court that allows us to look at the or to view the live streaming of some Supreme Court cases. So Justice Kant has this view in mind also, that he wants to increase the use of technology when it comes to the working of our Supreme Court. Now we'll also talk about the evolution of the appointment system when it comes to the judges of both Supreme Court and High Courts, because the Constitution has not mentioned any particular thing over here in some articles. So some articles becomes important for us in terms of the Chief Justice of India as well as in terms of the High Court judges. Some constitutional articles are important because the Constitution has not defined anything. So for that, some cases also become very important, which we will discuss. First, let's start with Article 124, Clause 2, which deals with the appointment of the judges of the Supreme Court. So, as per Article 124, Clause 2, the President is empowered to appoint the judges of the Supreme Court, including the Chief Justice of India, in consultation with any judges of the Supreme Court or the High Court as he may deem fit. So the keyword over here is consultation. The interpretation of the word consultation has basically led to the evolution of this appointment system that I'm talking about. So the corresponding article for High Courts here is Article 217. So what do you understand by this term consultation? So the term consultation has not been defined anywhere in the Constitution. That is why many interpretations came out in many landmark cases, and that defined the evolution of this appointment system. And those cases were the 3 judges cases. The first judges case, the second judges case, and the third judges case. So the first judges case of 1981. The first interpretation that came of the word consultation was that consultation is not equivalent to what? To concurrence. Consultation is not equivalent to concurrence, which means that the President is not bound to comply with the recommendations or to comply with the consultation that is being given by the judges of either the Supreme Court or the High Court, because consultation is not equivalent to concurrence. So these recommendations are not binding in nature as per the first judge's case, and this basically gave primacy to whom? To the executive. Executive had the primacy over judiciary because the consultation was not binding. Then something else happened in 1993. The second judge's case. Second judge's case of 1993. Another interpretation came in where basically it was said that the consultation is equivalent to concurrence. Earlier we said that the consultation is not equivalent to concurrence, then we said that yes, the consultation is equivalent to concurrence, which means that the consultation is what? It is binding. The recommendations that you receive are binding in nature. The President will have to act in accordance with the recommendations that are being given to him. Though the government can basically raise objections, it can raise objections to any names that are being given to it, and those objections can be raised only once. So the government can raise the objections will go back to the Collegium, and if the Collegium again feels that no, we want to go ahead with the same candidates, then that recommendation becomes binding in nature on the government as well as the President. So this is what happened in the second judge's case. Now I used the word Collegium over here. So this Collegium system, in principle, it came in the second judge's case. Now, collegium is basically a group of judges that is going to send in the recommendations, because what does the article say over here? Article 124 clause 2, that the president is going to take consultation from such judges of the Supreme Court or the High Court that he may deem fit. Now, these group of judges are kind of predefined and existing in an existing collegium system. A collegium was created where these judges of the Supreme Court and High Court are going to be predefined. Their designations are going to be predefined and the roles that they are playing are going to be predefined. Now, this collegium for Supreme Court, in the second judge's case, the collegium for Supreme Court consisted of the Chief Justice of India plus 2 other Supreme Court judges. So it was defined. What was defined in the collegium system? The number was defined, and it was defined that the Chief Justice of India will be a part of this entire collegium to make the recommendations. So in the second judge's case, this system came in principle, and then for SC it was defined that CJI plus 2 other judges are going to be a part of this, and they are going to send the recommendations to the Law Ministry. And then if the government has any objections, the objections can be raised once, but if the collegium decides that they want to go ahead with the same candidates, then that recommendation becomes binding on the government, and then the Prime Minister is going to advise the President, and the President will finally make that appointment. So this is what happened in the second judge's case. So this became a turning point, because now who received primacy? The judiciary. In the first judge's case, executive had the primacy over judiciary. In the second judge's case, judiciary had the primacy over executive. Now, what happened in the third judge's case? Now, third judge's case also becomes important. Third judge's case of 1998. Here, the collegium was expanded. So for the Supreme Court, the collegium has to consist of the Chief Justice of India plus 4 other SC judges. Under the second judge's case, it was 2 other SC judges. Now we have 4 other SC judges. And for High Court, it is the Chief Justice of that High Court plus 2 other judges. So the collegium for the Supreme Court was expanded, more judges were included, and what has happened in all these cases, the interpretation of the word consultation has come into picture. It has changed over time and has finally given rise to the current system of appointment that we have, that is via a collegium. So this is about the entire evolution of the appointment of the judges when it comes to the judges of Supreme Court and High Court. So that was all for this video. We saw that over time things have changed, the appointment process have changed, and if we talk about the 53rd Chief Justice of India, he has a vision in mind, and the goal over here is to reduce the pendency of cases in the Supreme Court as well as to increase the use of technology in the working of the court so that the lives of citizens, lawyers and judges can be made easier. So thank you for watching the video. Please go back and revise the entire the judiciary chapter for your examination. And now, as always, let us practice a question for prelims. With reference to recent developments in the Indian judiciary, consider the following statements. 1. Justice Surya Kant was part of the 16th Presidential Reference Constitution bench, which advised that the President and governors are not bound by judicially implied timelines while granting assent to state bills. 2. The collegium system for judicial appointments was created through the first judge's case and later expanded through the third judge's case. 3. The Chief Justice of India is a member of both the Supreme Court Collegium and the High Court Collegium. 4. Live streaming of Supreme Court proceedings can be accessed through an official mobile application launched by the Supreme Court of India. Which of the statements given above is or are correct? Please note down the options over here. A, 1 and 2 only. B, 2 and 3 only. C, 3 and 4 only. Or D, 1 and 4 only. A, 1 and 2 only, B, 2 and 3 only, C, 3 and 4 only, or D, 1 and 4 only. Please read the options carefully and provide your answers in the comment section. Thank you for watching.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.